You know, it's a crazy thought, but what if in a huge fight with your homeowners association, being right wasn't enough? What if it didn't matter at all? Well, we're about to dive into a legal case that boiled down to one tiny missed detail, a single piece of mail that was never even sent. Seriously, this story is a masterclass in how just following the rules can sometimes be way more important than the actual facts of the case. So here's how we're going to break it down. First, we'll look at how a pretty standard dispute over short-term rentals just blew up. Then we'll get into the nitty-gritty of the specific law at the heart of all this. After that, we'll walk through the first court ruling, a pretty dramatic second hearing, and finally, the big verdict and what it means for every single person living in an HOA. All right, let's meet our key players. On one side, we have the homeowner, Rogelio A. Garcia. On the other, the Villagio at Tempe Homeowners Association. And the fight starts over something you hear about all the time, right? An alleged violation for short-term rentals. But what started as just a routine notice, well, it spiraled into a massive legal battle, and it happened way faster than you'd think. And man, things escalated fast. Just look at this. March 8th, boom, first notice. Not even 2 weeks later, a second one shows up, but this time with a $1,000 fine attached. Then, another 2 weeks go by, and a third notice lands with another $2,000 in penalties. So in less than a single month, Mr. Garcia is suddenly staring down $3,000 in fines. I mean, talk about pressure. Okay, so here's where things get really interesting. Mr. Garcia doesn't just argue about the fines themselves. He goes way bigger. He decides to challenge the HOA's entire process, claiming they didn't follow the law. This wasn't just some neighborhood squabble anymore. This was an official legal challenge filed with the state of Arizona. The date to remember is August 17th. That's when he made it official. He wasn't debating the short-term rentals anymore. Nope. His entire argument now was that the HOA had broken a very specific state law, ARIZ Section 33-1242. And this one statute, well, it's about to become the main character of our whole story. Mr. Garcia's case was built on three main points. He claimed the HOA messed up by not 1, giving him the proper 21 days to respond by certified mail, 2, telling him who actually saw the violation, and 3, letting him know he had the right to a state hearing. And looking at that, you'd think, hey, that sounds like a pretty solid argument, right? And this is where we have to hit pause for a second, because everything that happens from this point on, all the arguments, the rulings, the whole thing, it all comes down to the exact wording of this one law. To really get why this case turned out the way it did, you have to understand the law itself. So, what is this law anyway? Basically, ARIZ 33-1242 is like a rule book for how homeowners and HOAs have to communicate after a violation is flagged. It lays out a very specific, step-by-step dance they both have to do. But, and this is a big but, there is a catch. Okay, so the law works on this really simple but super strict if-then logic. Think of it as a two-part domino effect. Step 1 is all on the homeowner. You have to send a written response by certified mail within 21 days. It's a must. And only if you do that does Step 2 even happen. That's when the HOA is legally required to give you more info, like who saw the violation. But here's the kicker, the part that this entire case hangs on. If you, the homeowner, never send that letter, the HOA's part of the deal is never activated. It's like the law is just dormant. No letter, no obligation. Period. Right, so keeping that legal trigger in mind, let's jump to the first hearing on October 30th, 2018. Both sides showed up and made their arguments, but really, the judge just had one job: apply that two-step rule to the facts that everyone agreed on. And the decision came back fast, and it was crystal clear. Petition dismissed. The judge ruled that Mr. Garcia simply didn't prove the HOA broke the law. But why? The judge's reasoning was just laser-focused on that two-step trigger. The facts were indisputed. Mr. Garcia never, ever sent that certified letter. He never did Step 1, and because of that, the HOA's legal duty to perform Step 2, it was never turned on. Legally speaking, they didn't have to do a thing. But hold on, the story isn't over yet. Mr. Garcia actually got a rehearing, a whole other bite at the apple, on February 12th, 2019. And this time, both sides came back to the table with some brand new strategies. So, Mr. Garcia's team tried a new angle. They argued that the HOA's notices were confusing, that the 10-day demand made it impossible for him to use his 21-day legal right. The HOA, meanwhile, pulled out a completely different defense. They said, hey, this law doesn't even apply here. It's for the condition of a property, like a broken fence, not the use, like short-term rentals. This rehearing also had a real moment of courtroom drama. A question got asked that seemed to cut through all the legal jargon and get right to the point. A question about what the HOA was really thinking. And this is the part that probably made jaws drop in the room. The HOA's manager is on the stand, and he's asked point blank, if Mr. Garcia had sent the letter, would you have followed the law? And his answer? A flat, simple no. I mean, wow, that feels like a smoking gun, right? But here's the thing. In the cold, hard world of legal procedure, that shocking no meant nothing. It was totally irrelevant. The judge basically said, look, what the HOA might have done is a hypothetical. The only thing that matters is what actually happened. And what happened was Mr. Garcia never sent the letter that would have started the whole process. And that brings us to the end of this whole saga. After all the back and forth, the new arguments, and that bombshell admission, it was time for the final decision. On March 4th, 2019, the final word came down, and it was exactly the same as the first one. Mr. Garcia's petition was dismissed, this time for good. The result just couldn't change, because the one crucial fact at the center of it all, the missing letter, had never changed. And it all comes down to this one simple number, 0. That's how many certified letters were sent. That's how many times step 1 of that legal process was ever started. In a case filled with complicated arguments, this one little fact was the only thing that mattered in the end. So, what do we take away from all this? The lesson is powerful. When it comes to legal fights, procedure is everything. Whether Mr. Garcia was right or wrong about the short-term rentals became a total non-issue. By missing that one first step, he basically locked himself out of his own case before it even got started. Which leaves all of us with a really important question to think about. In a dispute with your HOA, what's more important, being right about the facts or being right on the paperwork? Because as this whole story shows, sometimes the process isn't just part of the game, it is the entire game.